Well, good morning, everyone. Welcome to this King's Chambers Property Pick and Mix. I'm Nigel Clayton. I'm a property lawyer and member of the Business and Property Group at King's Chambers. And with Matthew Hall later this afternoon, we'll be introducing quite a few members of the property team and a surveyor, in fact, a guest speaker, to present some slots on various topical issues. Of course, it's about that time of year when we normally hold our flagship property conference, which is also a good excuse really to get together and catch up. But of course, things being as they are, we can't do that at the moment. So we thought we'd come up with the next best thing, which was to try and put together a property pick and mix. So you can pick out some seminars throughout the day and join in whenever you want. I think this was actually Geraint Wheatley's project, and he put it all together, and thanks to him for that. But unfortunately, he's tied up in court today, typically. But that also means that his slot at 2:15, which was going to present with John Hunter, one of our planning lawyers, has had to be postponed. So apologies for that. So just a quick run through the format for today. You may have our standard property pick and mix sort of info sheet. In a minute, I'm going to introduce Richard Lander. At 10:45, we've got Nick Taylor speaking about possessions during the pandemic. 11:30, the hugely experienced Wilson Horn on an overview of disclaimer at freehold and leaseholds. 12:45, Emily Duckworth, adverse possession of registered land following the interesting case of Dowse and Bradford Metropolitan Borough Council. 1:30, the brilliant Nigel Clayton will be talking about proprietary estoppel. As I say, we're missing the 2:15 slot with John Hunter and Geraint. At 3:30, we've got John Thompson, a surveyor, speaking about what's happening in the property market during the pandemic and what may happen next. At 4:15, Eleanor Darcy, again the brilliant Nigel Clayton, speaking about undue influence in mortgage litigation. And finally, but by no means least, at 5 o'clock, Dr. Nathan Smith, leasehold covenants, how enforceable are restraints of trade and restrictions on building work. So quite a range of stuff there to get through. And just before I hand over, a few obvious points to note. Each session has its own Zoom login. So at the end of each session, the Zoom connection will close. If you're wanting to log into the next seminar, you'll have to do that on a separate login. Many of the presenters will be using PowerPoint slides throughout the day, so there will be some switching between video and PowerPoint. So do please bear with us on the tech front for that. And finally, by all means, do feel free to use the chat function for any comments and questions. But if time permits, we'll try and get round to those and respond as best we can, but no guarantees, I'm afraid. And obviously, it's probably best to raise only short points rather than fairly lengthy, detailed queries. So apart from that, let's get on with our first speaker. Richard Lander, called to the bar in 1993. He has a busy chancery and commercial law practice, but with a particular emphasis on property-related law and litigation. He's a very busy litigator. He's also a hugely popular member of our team. So, Richard, good morning. How are you?
Well, thank you. How are you?
Very well, thanks, Richard. Nice to see you. I have to say I took a bit of a double take on the title of your presentation this morning. Crap witness statements, 50 ways to mess it up. Is that right? Have I made a mistake there?
You haven't made a mistake. There's probably not 50 ways, but I'll highlight the main ways to mess it up.
I've seen one or two of the slides. It looks great. So, Richard, straight over to you.
Thanks, Nigel. Thanks. If you bear with me a moment, I'll try and get my PowerPoint slides up. All right, I'm sorry about that. It's moved on. Right, let me start at the beginning. I took my inspiration for this talk from this great literary work that sits in the waiting room of the garage in Stockport, where I take my car. And you may be wondering, how did I set the criteria for what is and what is not a crap witness statement? Well, first of all, I sought contributions and got contributions from all of the specialist circuit judges sitting in the business and property courts in Manchester. I asked them what really annoyed them about witness statements that they saw in court. Secondly, I looked at the report of the Witness Evidence Working Group, which was essentially a group set up by the business and property courts in London, which reported last year. And then thirdly, I relied on my own experience as an advocate. One of the main functions as an advocate is to spot and to exploit the weaknesses in the other party's evidence, and in particular, those that you can spot in the other party's witness statements. So how do solicitors get it wrong? Well, there are some who really aren't up to the job. They don't try, or they're not up to it. Now, I know very well that none of you that are listening today will fall into that category. But the other category is those that are too clever or try too hard, genuinely doing the best for their clients, but perhaps in doing so actually turn what could be a good witness statement into a bad witness statement. And if you look at the report of the working group, what it says is that the heart of the report, and the reason it was set up, is the phenomenon of the overlong, over-lawyered trial witness statement. So what is the purpose of a witness statement? What are you trying to do when you help to draft a witness statement? So what we have really is it's an opportunity for the witness to present his or her admissible factual evidence to the judge in the most attractive way possible. Now that's my formulation. And it breaks down really for the purposes of today into three elements. First, the evidence has to be admissible. Secondly, it's factual evidence. And thirdly, you want to present it in the most attractive way possible. Admissibility, first of all. Now, an inadmissible witness statement is by definition a crap witness statement. And in my experience, a statement is most often inadmissible when it doesn't comply with the requirements as to hearsay. And the practice direction makes 2 points. First of all, that the witness has to indicate which of the statements are from the witness's own knowledge and which aren't. And then secondly, it has to state the source for any matters of information or belief. Now, if you look at the case reports, they're riddled with examples of this not being complied with and the judges having various things to say about it. I picked this one out simply because it's one of the recent ones. So the maker of a statement must not only provide the usual rubric, but meticulously comply with its requirements. And then at the end, strict compliance with the CPR is required if the party is to avoid the risk that limited or possibly no weight is given to the evidence. And so this is a paragraph that I've picked from a recent witness statement from the opposing party, as a liquidator, in a case of mine. And so what he says, the facts of matters disposed to herein are facts of matters which are known to me from my personal involvement with this matter, or from information supplied to me by either the office, by the other office holders, from the books and records of files relating to Company A and Company B. The facts herein may otherwise have been made known to me by members of my staff assisting in this matter, or from the solicitors instructing on behalf of the office holders, save where I otherwise refer. Now, this is something that somebody's gone to a lot of effort to write and is trying to comply with the practice direction, but in fact failing quite spectacularly because it doesn't comply with either limb. If you look at it carefully, it doesn't say what evidence is or is not hearsay, nor does it identify the actual source of that evidence which is hearsay. It's much easier in a witness statement just to have a short sentence saying something like, the contents of this witness statement are within my own knowledge unless another source of knowledge is indicated. And then when there is hearsay evidence, you identify it as you go along. In the worst case scenario, you can lose a case or an application for not getting it right. And Barclays Bank and Piper is now a very old case, but it's still good law. So Mr. Piper was running a pretty hopeless substantive defense to a bank claim, but his barrister argued on the hearing of a summary judgment application that the bank's evidence was defective because their witness did not indicate the source of the hearsay evidence in his affidavit. Still had affidavits in those days. So the witness thought, well, I'll sort this out. And he put in a second affidavit, which was not dissimilar from the paragraph that we've just looked at. It identified several sources of knowledge, but it didn't identify the source of each assertion. And as a result of that, it went to the Court of Appeal and they said, well, the summary judgment application is dismissed. Now, that used to be a really helpful case. It was the sort that you used to keep in your briefcase before we had computers and take round. And it was always the last port of call when you really had nothing else to argue substantively. And often it used to work. While I'm on the practice direction to part 32, most of you will be aware of the amendment that came in during the first lockdown about the words to be used in a statement of truth. But the other point that was added is this, that the statement should state the process by which it has been prepared, for example, face-to-face, over the telephone, and or through an interpreter. Now, this highlights another problem that was identified by the judges. When a witness goes into the box, that witness will often be asked if the words in the statement are their own words or the solicitor's words, or just simply, are they your own words? And they will invariably say yes, even if they aren't. And that instantly puts that witness on the back foot and in a state of panic because they realize that what they've said is wrong, but they felt that they ought to say it. And what one of the judges recommended was when you prepare a witness statement, why not give the detail as to how it was prepared? For instance, it was the solicitor that wrote it on the basis of information provided at a meeting, or the words are the client's words. Explain it, and then you can avoid your client getting into that difficult situation. The next point is that the evidence is to be factual evidence. And again, the judges noted that the idea of witness statements and the origin of witness statements is to replace evidence in chief. Nothing more and nothing less. And that again is reflected in the practice direction. And it's perhaps helpful when you're thinking about the contents of a witness statement to remember this. It's a good guide to what should go into a witness statement. So, first of all, would a witness be allowed to stand in the box and make legal submissions? I actually made this one up, but I've seen things in witness statements that are not a lot different from that. Would a witness be allowed to stand in the box and recite the correspondence at length? Would a witness be allowed to stand in a box and give his expert opinion on something? And then finally, would a witness be allowed to stand in the box and comment on somebody else's witness statement? Would you want to do anything like this? You see, all of these 4 headings represent things that should not, as a general rule, be in witness statements. And frankly, they can all give the witness the opportunity, quite a spectacular opportunity, to look completely stupid when they come to be cross-examined. So on one level, it can lead to a rebuke from the judge. And the Wetherspoon case is an example of that. Judges generally get more and more irate about this sort of thing. It builds up. I'm sorry, I think we might have somebody who's not muted and there's a noise coming on. I don't know if everybody could just check that they are muted. No, I think we'll have to we'll just carry on anyway. So judges get more and more annoyed by this sort of thing until they put out a practice note complaining about it. And this was one of those practice notes. So we had a 52-page, 231 paragraph witness statement, and the judge struck out all but paragraphs 1 and 2 and 7 to 11. And the basis for that was that it contained a recitation of facts based on documents, commentary on the documents, arguments, submissions, and expressions of opinion. And it was held to be an abuse. But getting the statement struck out can actually sometimes be the least of your worries. And the Alex Lorry case is a good example of this. Now, that's a case which is quite funny for most lawyers, probably not quite so funny for Mrs. Morgan. Now, she was running a defence based on Barclays Bank and O'Brien, undue influence, and she put in a really detailed affidavit setting out the law very clearly. And she lost at first instance because the court thought that by setting the law out so clearly, she demonstrated that she must have understood the position. And it was only when she got to the Court of Appeal that they came to her rescue, when it was apparent that she really had no input into her witness statement. This one is actually one of mine. One of the points that my client wanted to make was that he could rely on a trustee's lien. So his evidence was that as he retained legal ownership of the properties, holding the ownership on trust for the company. Now, as a matter of law, he didn't actually hold them on trust because of a slightly complicated quirk. And we went in front of Judge Halliwell, and he said, well, hard luck. That's an admission that he held them on trust, and that's binding under CPR 14. And again, it was the Court of Appeal that came to the rescue because it said, well, in actual fact, it wasn't an admission at all. There was nothing to admit, no allegation that they were held on trust, and it was simply the client's musings as to the law that he wouldn't be bound by. But again, it's a good lesson of what not to put in a witness statement. Like a lot of these things I'm talking about, there are exceptions to that. So for instance, if you're applying for relief from sanctions, it's helpful to set out the limbs of the Denton principles so that you've got a structure to your witness statement. And there may be cases where the witness is actually trying to show that they know what the law is. And I put on an example there of a solicitor trying to explain that he knows what the effect of the golden rule is, and explaining why he didn't comply with it in a particular case. Now, the next point is another important one. Whose evidence is it? And I'd say a good 50% of witness statements I see at trial get this wrong. It's not yours, and it's not that of another witness. I say it's not yours. You are solicitors. Your clients look up to you, particularly in matters of law. if you go to them with a witness statement that you've drafted on the basis of what you would think in a particular circumstance, with your own interpretation of the facts, many clients will agree with you. Going through the statements going through the documents without the client, preparing a witness statement, and then getting them to agree it is a recipe for disaster. And the other point, of course, on that slide from the judges, again, use of language, which is so far from the normal mode of speech, makes it clear that the witness doesn't understand what is being said. And if you're a good advocate, you can spot that a mile off. So this is how it goes wrong when you've projected your own thoughts onto a witness in the statement. And for an advocate cross-examining, it's dead easy. So the statement says, when I read that, I thought X. So you don't take the witness to the statement. You take them to the document. What did you think when you read the document at page 400? Answer, I don't know, or I thought it was Y. And so it's that easy, and a skillful advocate will spot that opportunity. And then you've got the next question. So whose opinion is it at paragraph 52 of the witness statement? And at that point, they've got no good answer, because they either say it's mine, in which case they've contradicted themselves within seconds, or they say, well, it must have been something my solicitor thought, in which case the whole basis of the witness statement is undermined. And so you've got a fundamentally honest witness looking shifty very easily. Using the words the clients wouldn't use or they wouldn't understand. Years ago, I used to defend high volume housing disrepair claims in the Northeast. And each case had a pre-prepared witness statement in identical terms, prepared by the solicitor with words introduced. So it would say something along these lines: I've been deeply distressed by the, and then they would insert the particular defect that the surveyor had found, normally pretty trivial. And then there used to be a lengthy explanation about how, as a result of this, they were embarrassed having friends around, etc. And so what I always used to do is you would take the witness to the photograph of their house in the trial bundle. And you say, look at the photograph of your house. Please, can you point to these soffit boards that are causing you such distress? And I never got the answer, yes, I can, here it is. They always said no, and they always lost. There was never a single instance where they were able to recover from that. And that's easy when there's obviously something in the witness statement that the client hasn't said. Now, this is another one. Judges were keen on this one as well. Never use the words of another witness. Never copy and paste between two statements. The judge's comments was that including the same text in more than one witness statement makes cross-examination like shooting fish in a barrel. And again, it's the panic that it puts into witnesses. They think they've made some grave misdemeanor by the fact that the wording is the same. And then they'll deny that they are not their own words when clearly they are. And again, you've made a fundamentally honest witness look quite dishonest. And then the third point is you want to try and present the evidence in the most attractive way possible. Now, one of the things in my experience that solicitors sometimes forget is what they are trying to do. Some think that their role is to get every possible detail and every possible argument into the witness statement, so that, like today, it can be dealt with on a pick and mix basis. When it gets to trial, the barrister can focus simply on the points that are good and ignore the points that are bad. And in doing that, I think a lot of people lose sight of what they're trying to do. Now, how do I illustrate this? This is a picture of a meal in a smart restaurant. This is the same meal in a big bag of lettuce. And this is the same meal, again, with the lettuce and with a snail on it. And I apologize for the quality of the special graphic effects, but hopefully it gets the point across. The first is an attractive, compact, well-presented meal. It's the center of attention on the plate and it looks appealing. What about the lettuce plate? The point that that plate is trying to make is that if you bury your good points in a massive inconsequential material, it will get lost. And first of all, remember that judges reading witness statements are human beings. They get bored reading lengthy, irrelevant material, just like we do. It's highly embarrassing when you're preparing a skeleton argument to have to say, read the witness statement of the claimant from paragraph 143 onwards. It was stressed to me by the judges, they don't want a detailed life history. And they certainly don't want extensive quotation from documents. And you've already seen what happens in those circumstances from the Wetherspoon case and the practice note. The statement only needs to deal with those issues which are actually in dispute. And the fundamental point is that the more attention is paid to the lettuce, the less attention is paid to the fish. What about the next stage along, the snail? Taking a bad point can be very damaging. It doesn't matter how good the fish is, the thing that draws your attention is the snail. Once you've seen the snail, the fish on your plate is never going to look as good again. If you go to TripAdvisor, look at restaurant reviews, you won't really find any say, well, it was a great meal, it was fantastic, apart from the slug on my plate. And again, it's this school of thought that we need to get away from, that all points, if all points are in there somewhere, you've done your job and therefore it's okay. It's not. 4 good points and 1 bad point is not the same as 4 good points. It's not even the same as 3 good points. Now, it's easy sometimes when you've got a difficult client to let them make bad points. Let them make points that they insist on making where you know that they're not going to be believed, for example. But it's your responsibility to advise them pretty robustly when they want to make bad points, not to do so. Otherwise, it can undermine the good points quite severely. Snail becomes the focus. The presence of the snail diverts most, if not all, attention from the fish. And finally, on this question of presenting the case in the most attractive way possible, remember that the witness statement is part of a team. It doesn't have to do everything. The pleadings set out the case. We know at the end of pleadings what is in dispute and what is not in dispute. The skeleton argument at trial will set out the law, and the oral submissions will bring everything together. And it comes back to this simple point. that the only thing that the statement has to do is to set out the factual evidence which the witness can give. And in particular, the factual evidence that that witness would have been able to do had that witness been put into the box. It's a bit like a team on a sports field. Each member has a role. If that person tries to take over another person's role, then it will generally go wrong. Now that's all I want to say about crap witness statements. One of the things that many of you may have been wondering from the first slide, just to finish on, is what was the #1 crap car in Britain? And I think the answer to that is probably more controversial than quite a lot of the things that I said this morning, because the answer is it's the VW Beetle. And at that point, I shall stop just about on time. Thank you very much for listening. I'm going to look at the chat, see if there's any particular questions. Yes, so there's a question about what is your view in relation to witnesses explaining disclosure in statements. Now, in relation to that, sometimes there are documents that need to be explained. For example, a situation where somebody's saying, well, they didn't receive a document, or they didn't agree with what was said in a document, or something like that. I think generally in relation to disclosure, unless there's something to explain as to what has happened in the disclosure process, I certainly wouldn't I wouldn't include great detail on the documents. The next question I've got here, is there a greater problem for litigators to put in irrelevant material due to limitations on the number of witness statements? There shouldn't be, because I mean, hopefully, if there's a limit on the number of witness statements, you can decide what is the relevant material and who's going to deal with what material in their witness statements. I'm trying to think of a specific example where that might happen, but I'm not sure that I can at the moment. On the question and answers, no, that's fine. I think that is it in terms of questions. If anybody else has got any more, then put them on the chat quickly. Otherwise, I shall sign off. No. Would I draw a distinction between a trial witness statement or a procedural witness statement? I think the answer to that is yes, to an extent, and I think you will get away in the procedural ones with a little bit more comment and a little bit more law. For instance, I had a case the other week where we were replying to a summary judgment application before the defence was in, and really had to set out a little bit more of what will be in the defence legal points there. So I think you can get away with a little bit more of that. You can also at that stage perhaps have a little bit more in terms of comments on the correspondence and documents. I think when you get to trial, it's a slightly purer form of what the witness would actually say in the box. But I think perhaps the distinction is, of course, in a procedural matter, the witness isn't going to go into the box, so you might have to have a little bit more. Do I find judges are more lenient with litigants in person? The answer to that, I think, is sometimes. There are some judges who bend over backwards to accommodate litigants in person, allow them to get away with a lot of things that really they shouldn't get away with. But at the same time, there are some who really have no time for litigants in person at all. I think you've got to sort of look at your judge, and there are some judges who will be more sympathetic when you come to argue that the litigant in person's witness statement is defective in one way or another. And so I think that's the that's the way to look at it. It varies on the judge, I think, is the answer to that. Right, I've been told to wrap this up. So thank you very much, all of you, for listening, and hopefully see you later on. Thanks. Bye.